Good evening, everyone. Today we have Mr. Pratik Datta and Ms. Rajeshwari Sengupta on Insolvency and Bankruptcy Code. I welcome both Rajeshwari and Pratik for today's webinar. Let's understand the law that is there, the existing situation, and like it will more or less we'll be talking on a perspective of what is the law on Insolvency and Bankruptcy Code that was earlier there. And then we'll progress to understand the current new law that has been passed by the parliament very recently. So Pratik and Rajeshwari, let's begin with today's webinar. So let's begin with understanding the existing framework of insolvency and bankruptcy laws in India. Is that the correct point to start on?
Yes, absolutely. Thank you so much. Good evening, everyone. So to give a quick introduction, I am Rajeshwari Sengupta. I'm an assistant professor of economics at the Indira Gandhi Institute of Development Research, that's IGIDR in Bombay. And I was part of the research secretariat for the Bankruptcy Law Reforms Committee that proposed this new law. So that is my involvement with the law, and I've been pretty much with it from the very inception. Pratik?
Yeah, so I'm a lawyer, and I have been working for the National Institute of Public Finance and Policy. National Institute of Public Finance and Policy, NIPF in short, is a think tank of the Ministry of Finance. We work as a technical research secretariat for a lot of the expert committees that get set up by the Ministry of Finance. In this specific case, it was the Bankruptcy Law Reforms Committee. So we along with Rajeshwari and the team, we assisted the BLRC in conceptualizing and drafting the Bankruptcy, Insolvency and Bankruptcy Code 2016, which got passed in May this year. So just to give you a brief introduction, the law has been passed, the implementation process is on, and this presentation will give you an overview, the economic principles, broad economic principles that guided framing of the law, the conceptualization of the law, and we will also give you a broad overview of what the law is. With that, I'll hand over to Rajeshwari.
Thank you, Pratik. So, as Pratik mentioned, the talk for today will be split into two parts. In the first part, I will cover the economic principles and the rationale behind the law. I'll also talk about the present insolvency framework in India in a pre-IBC world, and what are the problems that we are facing in this framework. And then I'll hand it over to Pratik, who will take you through the different principles of design of the specific law and the various institutions proposed by the IBC. So if we start, I'll move over to the slide which is on the outline. So as I said, essentially the first part will be elements of a sound insolvency system and the present framework in India and related problems, followed by the BLRC approach, which was the committee approach that led to the Insolvency and the Bankruptcy Code of 2016. And then we end with the way forward. So moving on to the slide on definitions, just to ensure that everybody is on the same page, I want to start with a few common definitions that are very useful in the context of an insolvency law. The first is the idea of a default. And essentially it's the simple notion that whenever a borrower fails to make a repayment, that is essentially what we call default. And that could be a corporate borrower, that could be you and I, an individual borrower. But whenever the debtor, the borrower, fails to repay, that is the notion of default. The second is the very important concept of insolvency. And here it is very important to distinguish between insolvency on one hand and bankruptcy on the other. And this is what is reflected in the naming of the new law as well. The idea is that when the borrower is unable to repay the debt, that is the state of insolvency. And that is what we call, it is a state of financial failure. So it could be that there is a temporary credit crunch, there is a temporary problem for which the borrower is unable to make payment. And nothing fundamentally or structurally is wrong with the business model of the company. It is a temporary financial problem. And that's why the borrower is not able to pay, is insolvent. When that is the case, the way to resolve that insolvency is what we call rehabilitation, reorganization, so on and so forth. Okay, so that's the revival of the company where any kind of financial arrangement is done so that you can tide over the temporary financial crisis. That is different from the notion of bankruptcy, which is a lot more serious because A bankruptcy is when the business model of the corporate borrower or the company is flawed. So there is some structural problem in the business model itself, and this is what we call a business failure. And when there is a business failure, then no amount of financial rearrangement will be able to save that company. So instead of wasting resources and time in trying to financially revive the company, the best idea is to then liquidate or wind down the company, or in simple word, to shut down the business. Okay, so it's important to understand that if there is a financial failure, that leads to insolvency. And when there is an insolvency, that firm or company should be revived or restructured. Whereas if there is a business failure, that leads to bankruptcy. And when there is a bankruptcy, then that enterprise or company should be liquidated or shut down. So that's the fundamental notion of any insolvency framework. Moving on to the next slide, elements of a sound insolvency system. So the layout of any bankruptcy law, what are the elements that any bankruptcy law should keep in mind? Now the idea is the purpose of any law is to give incentive such that all the agents who are involved as parties in that law should get the most optimal outcome out of that law. Now, which are the economic agents in a bankruptcy process? These are the debtors or the borrower on one hand, and the creditors or the lender on the other hand. So the idea of a good bankruptcy law is the law should be designed such that the socially optimal behavior on the part of the creditors and the debtors is incentivized by the law. Okay, so what is optimal in the context of insolvency and bankruptcy? The losses to all the parties concerned, again the losses to the creditors and the losses to the debtors, should be as minimum as possible. Okay, so that's the social optimal behavior. To turn it the other way around, the returns to the creditor should be as high as possible. So that is the outcome that we would expect out of a good bankruptcy law. Moving on to the next slide. That's the underlying principles of any bankruptcy law. So in that, what needs to be respected is that failure of a business is a normal thing. Okay, so what do I mean by that? Out of 100 businesses that are set up in an economy, it's highly possible that 10 or 20 of them would fail. That is a very natural thing for any entrepreneurial venture. When you set up a Oyo rooms, when you set up an Ola, when you set up an Uber, out of one Ola that has come up, it's possible that 50 other similar models must have failed. Out of one Oyo rooms that has come up, it's possible 20 other similar models must have failed. So business failure is a normal thing. It is not something that we need to do a naming and shaming of, or start criminalizing it, or start blaming the entrepreneurs or promoters. It is a normal process of a capitalistic structure. Having recognized that, when there is a business failure, it is very important to recognize that there is a limited liability with which that business was started, and upon failure, that limited liability needs to be respected. What do I mean by that? As long as the business, or as long as the firm is solvent, is able to repay the debt, then the shareholders or the equity holders retain control of the company. That is what limited liability means. But the moment that firm becomes insolvent, the moment the company is unable to repay the debt, that's the moment when the control should pass over from the shareholders to the creditors of the company, or essentially the bankers or the bond people who have given credit, who have given debt to the company. So that change of control from the equity holders to the creditors is something that needs to be respected whenever there is a failure of business. The third point in terms of principles of bankruptcy law, which is very important, is that time is of essence. Because the longer it takes to resolve a bankruptcy, the faster the depreciation of the assets, the faster the assets lose their economic value. So the speed of resolution is very important to ensure that the capital and the labor, which are the resources of production put in any business, they are released quickly and they are put into alternative uses which are more viable enterprises. So the speed of resolution is a very, very critical thing in any good bankruptcy law. And the final point, which is very relevant in Indian context, is the decision that whether a company is undergoing a financial failure, whether it is going through a business failure, whether it should be revived or whether it should be liquidated, that is essentially a commercial decision. It is a business decision that should be taken by the creditors of the company. This is not a decision that the judiciary should be involved in, because the judges or the lawyers, do not necessarily have the expertise needed to take this decision. So if you're involving the judiciary to take a commercial decision, that could lead to unnecessary delays, and that is very harmful for a bankruptcy process. So with that in mind, I move on to the next slide, and I'll primarily skip this. This is essentially repeating the same point that when an enterprise is facing a financial failure, it is still a viable enterprise. So the only thing that can be done is a financial rearrangement. Whereas when an enterprise is facing a business failure, that is essentially an unviable model, and that's when the enterprise should be shut down as soon as possible. So the next slide is what we see in India. So having talked about what are the economic principles underlying a law, good bankruptcy law, and what are the features that should be there in a proper insolvency framework, we find that none of these is present in India. Instead, what we see in India today is there is very weak state capacity or even private capacity to separate theft from business and genuine business failure. So today, if a Vijay Mallya is stealing from the company, as opposed to Kingfisher Airlines going through a genuine business failure because of some economic conditions, we don't have a capacity in India to separate these two cases. We tend to club these two cases under the same umbrella of saying the promoter is bad and therefore this needs to be dealt in a criminal law way. Or we say that the business failure, even if there is a business failure, it takes very long time to resolve it because the appropriate legal mechanism is not there. So that inability to quickly decide whether it's going through a financial failure or a business failure, that has proved to be very costly in India over time. Typically, when there is an insolvency situation, there are three possible recourses that can be taken by creditors. The first is called enforcement of collateral. So a financial creditor like a bank, like State Bank of India, has given a loan against the collateral of a factory of a company. When the company defaults on its debt, the creditor should have recourse to enforce the collateral, meaning the creditor should be able to sell off the asset and recover its own dues. In India today, this is possible under the law called Sarfazi, which came out in the early 2000s. So under Sarfazi, all banks are empowered to seize the collateral when there is a default. But the problem is this right is being given only to banks and a few non-bank finance companies now. All other non-bank financial entities do not have the right to do any debt recovery under the present legal mechanism. Second action available to creditors is on collective action. This is currently absent in India. Collective action means that all creditors, not just the banks or the secured creditors, all creditors should be able to come together and should be able to use the legal mechanism to do resolution of a company which has defaulted on their debt. So currently the closest we have to this is corporate debt restructuring or statutory debt restructuring, the CDR, SDR mechanisms that have been initiated by the Reserve Bank of India. But other than that, we don't have any collective action that facilitates an insolvency resolution of the company, where all creditors can come in the same forum. Finally, another recourse of the creditors that they should have is liquidation. They should be able to liquidate the company when there is a business failure. Currently, we have liquidation provisions in the Companies Act, but liquidation can take anything from 5 to 20 years, and that is again a very costly process in India. So the sum total of what I'm saying essentially leads down to the last line on the slide, which is that the estimated recovery rate in India is as low as 20%. This means that if a creditor, if a bank has given 20 rupees in 100 rupees in loan, the max that the creditor can recover is only 20 rupees. As a benchmark, the recovery rate in the US is as high as 80%. In Singapore, it's as high as 90%. So that shows the amount of risk the creditors are taking in India to offer credit to a starting entrepreneurial venture. And that also increases the cost of capital as a result of this low recovery rate. The next slide is on general progression of a country's bankruptcy law. I'll skip the next slide and the slide after that in the interest of time, and also because we have pretty much covered these points. So I'll move on to the slide which starts with elements of a sound insolvency system. So roughly the economics of insolvency reform should focus on 4 broad points. The slide on economics of insolvency reform talks about breadth and depth of credit markets, So in a situation where lenders are able to enforce repayment, lot of good outcomes happen. For example, there is greater credit access. There is credit access at a lower price because the lenders do not have to charge a very high rate of interest, because they know that if they have offered the credit, they can exit very quickly because there is a proper insolvency framework in place. The lenders need not do a very high collateral requirement because once again, they don't need that additional risk insurance because there is an insolvency exit framework in place. And also credit is available from a greater number and variety of lenders because all lenders can then take recourse to the insolvency reform to recover their dues. Secondly, a related point is this also instills commercial confidence and predictability. Because if you have a functioning insolvency system, then lenders are able to price risk more accurately, which means that the cost of capital is much more reasonable and the lender is able to manage the risk more effectively. Because the predictability of the system is much higher. This also balances the commercial relation between the debtor and the creditor. So if you remember, I was talking about the socially optimal behavior on the part of debtors and creditors. Essentially, their incentives then fall in line and then their losses are minimized. So that balances the commercial relation between the debtor and the lender. And finally, in a good insolvency framework, there is efficient allocation of resources. So the moment there is a possibility of an exit, entrepreneurship gets more encouraged in that environment because I'm able to exit a failed venture very quickly and I can then engage the capital and labor in my next venture much more rapidly. And that is exactly what we want in a country like India, where we're trying to do a lot of startups, where we are trying to do a lot of entrepreneurial ventures. Moving on to the next slide. So what is wrong with the present insolvency framework in India in the light of what we have just discussed? If you look at this chart, even if we don't go into the details of it, what it essentially shows is the insolvency framework in India, it has evolved over a period of time in a very piecemeal, haphazard fashion. So we started off with 1920, that's the first bar of the Presidency Towns Insolvency Act of 1909. That is essentially the Insolvency Act that governs personal insolvency of people living in the Presidency Towns of Calcutta, Bombay, Madras, and Delhi. The people living in the non-Presidency towns had recourse to the Provincial Insolvency Act of 1920. And till today, these are the personal insolvency laws that are still prevalent, which are more than 100 years old. And that's how bad the situation is on the personal insolvency front. On the corporate insolvency front, which is the second bar, all winding up or liquidation provisions of companies were incorporated in the Companies Act of 1956. So companies could be liquidated under the Companies Act, but there was no restructuring provision. So if you had a financial failure, the revival of the company was uncertain how it could be done. Finally, SICA, which is the Sikh Industrial Companies Act, that came up in 1985. And that was for the rehabilitation of all the heavy industries that were set up from the 50s to the 80s in India. And from there on, we have had a very rapid phase of evolution of insolvency laws. Standing today, which is the last bar, today we have a Companies Act of 2013 under which winding up can be done. A SICA, a very fragmented, ill-designed SICA, under which there is some rehabilitation provision. We have CDR guidelines issued by the RBI. We have a SARFAESI, which is only pertaining to the banks. So it is a very fragmented, haphazard picture that we get from the current insolvency framework. And that itself is very costly because you don't get any of the sound economic principles that I've been talking about so far. Moving on to the next slide, economic and legal outcomes. So as a result of this fragmented framework, what has happened is all the outcomes in terms of legal outcomes or economic outcomes have been quite inferior over the last 20-30 years. So if you move on to the enforcement framework outcome slide, it shows that out of, let's say, we have debt recovery tribunals, roughly 33 debt recovery tribunals in the country. The total number of pending cases is anything from 60,000 to 1 lakh. Debt recovery tribunals are dealing with the SARFAESI cases. This shows how overburdened the DRTs are to deal with the SARFAESI cases, and as a result, the recovery rate is as low as 14%. SARFAESI referrals have been as high as 12.5 lakh in 2015. Despite that, recovery rates are as low as 24% because majority of these cases are either not being dealt with because DRTs are overburdened or because the cases are ending up as appeals in the DRT. So the whole purpose that SARFAESI would enable the secure creditors like banks to recover their dues, that entire notion has essentially failed because SARFAESI outcomes have not been very good. The next slide talks about insolvency framework outcomes. So we have about 9 lakh active companies in India in 2014. Out of that, only 300 to 400 new winding up cases end up in the high courts, which means a large number of cases, even if the companies are insolvent, are not even coming to the high courts, presumably because of the fact that the courts are highly overburdened, or we don't have a coherent legislative framework within which the insolvency of these companies can be resolved. And all of the statistics in this slide essentially goes on to show how much time consuming an insolvency process is and how overburdened our courts and our tribunals are. The next slide shows the outcomes on the workout mechanism. Workout meaning out of court mechanisms like CDR and SDR. These are guidelines issued by the RBI. Even these mechanisms have been a failure because of the way they have been designed. So they essentially give the creditors or the firms, the corporate debtor, a mechanism to do an extend and pretend. So you have a problem, but you have a temporary solution to tide over the problem for the time being, but you're not solving the fundamental problem of the company or the particular asset. Instead, you're doing an extend and pretend, and you're moving on, you're kicking the can forward. So that has further compounded the problem of non-performing assets of the banks because these guidelines are not solving the main issue. The next slide is on legal outcomes. Essentially, as a result of the fact that we don't have a well-defined bankruptcy law, what has happened is the legal framework today, as you can already understand from this, is highly complex and fragmented. Okay? So our courts have insufficient institutional capacity. We don't have good insolvency professionals to deal with the insolvency resolution of failed companies. Even strong laws like SARFAESI was not able to improve the recovery rate. There is no clarity of priority between laws and the fora. So there is no clarity on which law will supersede which law. Or there are instances where for the same company, there are cases which are being dealt with at the BIFR as well as at the High Court. And these cases drag on for years and years. As a result, labor and capital remain stuck in the failed enterprises. So this leads to very low predictability of resolution, high pendency of cases, and very poor recovery rate. The next slide shows the level of uncertainty in the existing legal framework. So for example, the trigger, essentially the point at which an insolvency proceeding is started. In some cases, it is too late. In some cases, it is too early. So for example, SICA says that insolvency proceeding can be triggered if 50% of net worth of the company is eroded. Now that is a very, very high threshold because by the time 50% of net worth is eroded, not much may be left in the company to rescue in the form of a revival or a restructuring. Contrast this with Winding Up Under Companies Act, which says liquidation can happen if there is a default worth INR 500. And that is a very, very low threshold, which means a company can be shut down if a default of as low as 500 rupees has happened. So these are two extremities of a revival happening only at 50% of net worth being eroded, whereas a liquidation happening on a default of as low as 500 rupees. Likewise, SARFAESI says that debt recovery will happen upon 90 days of NPA being declared. So there is no consistency across all of these thresholds that are spread across the multiple laws in the current framework. There is no collective action process in which all creditors can come together in one forum and decide whether a firm or a company is financially viable or whether there is a business failure. The distribution waterfall, essentially the waterfall by which the priorities of the various creditors will be decided, that is very complicated. Moving on to the next slide. And this essentially, the next two slides essentially show or further reinforce how bad the situation is in India compared to the rest of the world. So in the World Bank Doing Business ranking, it's something that the government has been giving a lot of importance to. In the resolving insolvency parameter, if you can see, India ranks as low as 136 out of an odd 180 countries, Countries like US, UK, Singapore, Canada, some of our major trading partners, their resolving insolvency is in the top 20 or top 25. If you look at getting credit, the rank of India is 42. The developed countries rank is from 1 to 20. So that is how difficult it is in getting credit in India if you want to start a business today, for all the reasons that I outlined so far. Moving on to the next slide. Low debt financing for firms. Now, because it is so difficult for the creditors to understand the predictability of the scenario, that if the firm fails today, whether I'll be able to recover my dues or not, most of the firms today are financed by equity instead of being financed by debt. Equity financing for firms can be very costly. It is a very risky way to finance a starting entrepreneurial venture. Ideally, what should happen is firms should have access to widespread debt financing. And that can only happen when the creditors have that guarantee that if something goes wrong today, I'll be able to recover my dues within 6 months' time. But that guarantee today is not there in India. So that ends up with the outcome of very low debt financing for firms in India. The next slide shows essentially what we keep reading in news a lot these days is there's a lot of non-performing asset stress in the banking sector. And if there was a proper insolvency framework in place, a lot of this non-performing stress could have been resolved much quickly and the banking sector could have started functioning more normally by now. But because we don't have an effective insolvency framework, all of these non-performing assets remain stuck in the banking system and they're not getting resolved for lack of a proper legislative framework. So the final part of my talk, I'm running against the time before handing over to Pratik, reforms of Indian bankruptcy. So the slide titled previous reform efforts. What has happened is it's not that the problems have been recognized only now. For the last 10-20 years, we have been recognizing there are problems and we have formed several committees to address the problems. And this shows from 1960s to 2014, the number of committees that were formed to address problems in the insolvency and bankruptcy framework in India. So all the SICA, the SARFAESI, all of these acts were essentially outcomes of recommendations made by these committees. But essentially what was happening was that the committees were making recommendations in a piecemeal manner. With every committee, the interest of one particular group was getting served. So for example, with SARFAESI, the interest of the banks or the secured creditors were getting served, but nobody was interested in looking at the bondholders or the employees, for example. Same with CDR, again, it was the banks that were being catered to, not necessarily all the creditors of the economy. So that further compounded the problem of having a highly fragmented framework. Finally, in 2014, that's the last committee, the Bankruptcy Law Reforms Committee or the BLRC was formed by the Ministry of Finance. And the BLRC recommended the Insolvency and Bankruptcy Code of 2016, which is what we have today, which is the law that got passed in May of this year. And finally, for the first time, there is one single piece of legislation that will supersede all existing laws. And that will talk about insolvency and bankruptcy resolution of both companies and individuals. And even in companies, it will give insolvency triggering rights to all kinds of creditors and not just the banks. So with that, I will give it to Pratik to talk us through the different principles and the elements of the law.
Thank you, Rajeshwari. So I'll move on into the second last part, which is on the approach adopted by the BLRC. So the first slide is on the IBC 2016 and the design principles. Now there are basically 7 principles. I mean, these have already been discussed by Rajeshwari. So I'll just sum them up in 7 principles. So the first principle is that there's a lot of problem if you put the same law dealing with the same subject matter across different pieces of acts or statutes. For example, if you have, say, 2 different statutes and each of them have a non-obstante clause, one saying that notwithstanding anything else, this law shall prevail, and the same provision is there in the other law, which one will prevail over which one? We have seen these problems across different laws. So there are n number of such problems that crop up if you have multiple pieces of legislation on a same subject. Therefore, the first principle is that replace multiple laws with one consolidated law. In other words, have a code on the subject of insolvency and bankruptcy. That's the first principle. Second is have a clear point of time when the transfer of control from equity holders to debt holders happen. So as Rajeshwari said, you need to respect the principle of limited liability. So once the shareholders have been managing a company and the company defaults on a payment, control over the company should shift to the debt holders, the creditors of the company. Now that point of time has been very crisply defined in the law as a default. Related to this is also the issue of solving the information asymmetry. Say for example, I take a loan from you, a loan of 1 crore to run a business, manufacturing bicycles, say, for which you have given me the loan. Now, I certainly have a better understanding of my business than you do because you are not managing my business. Therefore, I have more information about my bicycle factory than you do about the bicycle factory. So, there is an inherent information asymmetry that a creditor will always have lesser information than the debtor who's borrowed the money from the creditor. So, this information asymmetry problem also gets resolved on the passage of the control from the debtor to the creditors. So once control has passed on to the banks will get all the information about the bicycle factory and the conditions of it. If you do not allow that, then the debtor can siphon off assets or money from the business and take it out. So this information asymmetry problem is being resolved by transfer of control from the equity holders to the debt holders. The fourth principle is preserving the economic value of the firm. Now, this is the point that has been pointed out during the entire DLRC process by a lot of foreign distressed asset funds. Now, whenever someone wants to invest in distressed assets, they need clarity that the law should be clear that how much of time would it take to resolve this issue. That's why this law provides for a time-bound manner in which the resolution has to happen. So this is again one principle which basically is aiming to preserve the value of the firm, because if litigation goes on for the next 15 years, the value of the firm will get lost. So you want to resolve the problem at the earliest within a time-bound framework. The fifth is collective decision-making process. Now during the insolvency resolution process, and I'll come to it later. Say if I have taken a loan from you as well as 3 other people, and I default on the loan that you had paid me. Now everyone will be in a panic, right? So if you have paid me 100 rupees and I have defaulted on that loan, anyone else who's paid me would obviously want their amount to be returned back by me to them. So therefore, each individual creditor will want to enforce their creditor's right against me and take away their assets from me. But if that starts happening, if my assets are taken away, take example of a bicycle factory. Now, if my machinery is being taken away by each of the creditors, then my business cannot work out. And therefore, just because I've defaulted on one loan, that will trigger a domino effect and everyone will start taking assets away from me, and therefore my business will collapse. So in order to prevent that from happening, you need a moratorium process in which every creditor can come together and work out a solution without stripping off my assets from my business and leading to the collapse of the business. The sixth point is that whether a business is suffering from a financial failure or a business failure is a commercial decision. This decision cannot be taken by anyone other than the creditors whose money is on the line. This decision cannot be taken by the state, by the judge or lawyers. This decision is an inherent business decision that must be taken by the creditors of that company. So this is another fundamental principle. And the last principle is minimize adjudication. Only for legal processes have adjudication. It means basically that an adjudication can be on 2 issues. It can be on a factual dispute or else on a legal dispute. Now, the moment you go into a factual dispute, as lawyers, you will understand that it leads to an entire trial process. There has to be a fact finding, to come to the conclusion that what is the relevant fact, and on that basis, you come to the legal dispute. So the entire point of reducing time taken by a court would ultimately lead to reducing the time taken for adjudication of factual disputes. So the idea is if you can minimize the time taken by courts on factual disputes, then the total time taken by courts for adjudicating would go down. And this principle has also designed some of the institutional framework that supports the Insolvency and Bankruptcy Code. Now moving on onto the institutional infrastructure which supports these principles, IBC provides 3 new institutions. So the first institution that the IBC provides for is it talks of a private competitive industry of regulated information utilities. So what are information utilities? Information utilities are somewhat like what depositories are in the stock market. So basically you have all digitized information of all credit transactions registered with an information utility, So at the time when a dispute arises, all that the judge needs to look into is what is the record with the information utility. That is an indisputable evidence of the fact that the credit transaction has happened and the fact that a default has taken place. Therefore, you are eradicating, because you have a digital database of this information which has conclusive proof in the eyes of law. You are doing away with any possibility of a factual dispute arising as to whether there was a loan or whether there was a default on a loan. The second institutional feature that IBC talks about is the insolvency professional. Now, as we discussed, on the happening of default, control will pass from the equity holders of a company to the creditors of the company. Let's take the example of a oil and gas company. Some banks have lent, say, 100 crore rupees to an oil and gas company. Now, it has defaulted on the payment. Now, if the control is going to pass from the equity holders of that company to the banks. Now, the banks do not know the oil and gas industry at all. How will they manage the company? So they would need some expertise in order to manage this company through the restructuring and, if required, the liquidation process. So this specialized skill set will be there with these professionals called insolvency professionals. So the IBC talks about creation of a new profession of insolvency professionals. Now we have first an industry of information utilities, a private competitive industry. The second is a private competitive industry of regulated insolvency professionals. Now, both these industries, one of information utilities as well as the insolvency professionals, they need to be regulated, right? So that's why you need a regulator. So the third institution that the IBC proposes is a regulator. Over and above regulating insolvency professionals and the information utilities, the regulator will also issue subordinate legislations under the IBC for the insolvency resolution as well as the liquidation processes. So in all, the IBC is providing for three institutions: information utilities, insolvency professionals, and a regulator. Now moving ahead, I'll give you a basic overview of the processes under the IBC. So the basic design. So when an enterprise is facing distress, IBC proposes two steps. The first step is you have to resolve insolvency. As Rajeshwari pointed out the difference between insolvency and bankruptcy. So insolvency is a state when you are undergoing distress. Now the distress may be because of a financial stress or a genuine business failure, when the business itself, the business model is flawed and cannot work. Now you need some time to come to the conclusion as to whether this is a business failure or a financial failure. Now you do that during the insolvency resolution process. So the IBC says that on happening of a default, the creditor or any of the other financial creditors can trigger the insolvency resolution process. So basically they will go to the adjudication officer, the NCLT, and file an application for triggering the insolvency resolution process. They will annex the records from the IU suggesting that there has been a default and that if this is the case, fit for initiating the IRP. Therefore, the adjudicating authority will just cross-check with the data or the information from the information utility, and based on that pass an insolvency resolution process initiation order. Now, once this order has been passed, there is a 180 days time frame, which is extendable by another 90 days. So total can be 270 days, not beyond that. Now, within this 180 days, the IP will go through the records of the company, the credit records. Based on that, he will issue notices to all the creditors, and the creditors will come together and form the creditors committee or the committee of creditors, the COC. Now, the COC takes a decision whether this company is undergoing a financial stress or is it an actual business failure. Based on that decision, they will take a call as to whether a restructuring can be done or they will have to liquidate the company. Now, this entire thing has to be done within 180 days. If the COC fails to do it within 180 days, then the company automatically goes into liquidation. However, if the COC comes to the conclusion that this company can be revived, then they can enter into a restructuring plan based on a 75% vote on the basis of the credit, and accordingly the resolution plan will have to be approved by the adjudicating officer, the NCLT, and then the company can go into the restructuring process. However, if the COC realizes that no, this is not a case of financial stress, it's a case of business failure, and there is no point in continuing with the business, the COC can decide to go for a liquidation. Again, they will apply to the adjudicator, the NCLT, and the NCLT, if it is satisfied, will pass a liquidation order. Now, based on the liquidation order, the company will go into the liquidation process. Now, just moving on into the IRP trigger. So anyone with an undisputed credit claim can trigger the process as I explained. This comes from, so this can be the operational creditor, the financial creditor, or the debtor itself. So three people, any of them can trigger the IRP process provided they have an undisputed credit claim. Now this undisputed credit claim, as I explained, the proof of that would be the digitized record before the IE. So that record would give you a clear proof of an undisputed credit claim. And based on that, the IRP process can be triggered. Now, the benefits of this trigger, as I mentioned, is that the control over the company will pass on from the equity holders onto the creditors. By creditors, I mean ultimately the COC, the Committee of Creditors. And as we explained, this relates back to all solving the problems of information asymmetry, etc. Now, I have already covered all of this, so I'll just give you an overview of the IRP process. The IRP process that I mentioned of the 180 days, this is the time frame when the creditors committee will come together and take a call as to whether the business can go on or not, right? So this is called the calm period. During this time, you don't want each of the individual creditors to use surfacey rights or other individual debt enforcement mechanism against the company and take away the assets, because then the business cannot run for this 180 days, right? So therefore, you need a moratorium. So the moment IRP initiation trigger is generated, there's a moratorium till the IRP comes to an end. So during this moratorium period, no litigation can be filed against the debtor company. That's one unique feature of the IBC. Second is that the moment the IRP order is given, the order will also mention an interim resolution professional. So this interim resolution professional will ultimately within 14 days create the creditors committee. Now, during this period of time, the management powers are with the interim resolution professional. However, the moment the creditors committee is formed, the creditors committee acts through the IP, through the insolvency professional in managing the company. So, this is just to explain you how the control over the company shifts from the equity holder onto the creditors of the company. So first, the initiation has to happen, the IRP trigger has to be pulled. The moment IRP trigger is pulled, the interim resolution professional takes charge of the company and creates the COC, the Committee of Creditors. The moment Committee of Creditors comes into the picture, now the management is taken care of by the Committee of Creditors. Now, if the Committee of Creditors wants, they can keep the same interim resolution professional for the rest of the IRP process, or else they can get their own resolution professional also. Any plan that the COC arrives at has to be agreed to by at least 75% votes in the committee. So for the COC to agree to a proposal for restructuring, it has to have 75% vote of the financial creditors. Based on this, they will apply for a sanction from the NCLT, and the NCLT, based on whether all the legal process has been made, will give an order agreeing to the scheme. Note here that this is something is very important, that NCLT does not go beyond the legal process, because as we mentioned, one of the fundamental characteristics of the IBC is that the decision of whether a failure is a financial failure or a business failure is a commercial decision. That decision is not to be taken by the NCLT. That decision is to be taken by the creditors, and the court cannot go into the merits of the decision. All that the court can look into is whether the process has been followed by the Committee of Creditors as well as by the IP in coming to the conclusion. So the main principle is that the court is only looking into the legal process and not into the substantive merit. Now, the step 2 is liquidation. Now, how will a company enter into liquidation? There are three possible processes, right? One is that the creditors committee cannot decide whether it's a business failure or a financial failure within the 180 days. If they fail to come to that conclusion within 180 days and the NCLT does not extend it beyond 180 days by giving the extra 90 days, or even if they have given the extra 90 days, the creditor committee still fails to come to the decision, then automatically the company goes into liquidation. That is the one way of the company going into liquidation. The second way a company can go into liquidation is the COC itself realizes that this is a business failure, that the business model itself won't work, and therefore ask the NCLT to pass a liquidation order. So that's the second option. The third is, if the COC comes to a conclusion that no, this is a financial failure and it can be restructured, they enter into a scheme for restructuring and that is approved by the NCLT. However, subsequently, there is a breach of the conditions of restructuring by the debtor company itself. Then the debtor company can again be pushed back into liquidation. So basically, there are three ways in which a company can move into liquidation. In liquidation, the IBC provides for a clear process or a priority, as there is in the Companies Act. There's a similar priority of claims provision in the IBC. So according to that priority, the creditors will stand in line, and accordingly they will get their due from the debtors bankruptcy estate. Now, with that, we have given you a brief overview of the design principles of the Insolvency and Bankruptcy Code. We have explained you what are the processes for triggering the insolvency resolution process, how will that be managed, and how will the company, or how can the company go into the liquidation process if essential. Now, with that, I will hand over to Rajeshwari to explain what has been the development vis-a-vis the implementation of the code till now and what is the way forward.
Thank you, Pratik. So in terms of slide on the way forward, we basically just have one slide, the last one, which says implementation, cautious optimism. But before going into that, I just want to quickly give an overview of what's happening right now in terms of the law. So the Insolvency and the Bankruptcy Code 2016 is housed in the Ministry of Corporate Affairs. So that's the ministry that has taken upon the responsibility of implementing the law. The first section of the law that has been notified essentially has to do with the regulator, the one that Pratik mentioned. It's called the Insolvency and Bankruptcy Board of India, IBBI. The regulator will be headquartered out of Delhi. The chairman of the regulator has also been appointed. That's Mr. M.S. Sahu. And a few other members have also been appointed. And the hope is over the next couple of months, the other independent directors of the board and other employees will also get appointed. Once the regulator starts functioning, and that because that's the most important institution set up by the IBC, the next important institution is the industry of insolvency professionals, because without IPs, essentially the law cannot really function. So what is happening right now is draft regulations governing the registration of IPs, IP agencies. These have already been put up by the MCA for public consultation. The MCA is now considering the public comments that they have received, and revised regulations will soon be finalized. And then once those regulations are out, the first IP exam will be held, most likely in the next 1 month or so. And once the IP exam is held, any lawyer, accountant, management professional with experience will be able to take that IP exam. The exam will primarily be on the knowledge of the law itself, nothing much else, because we don't really have case laws right now. And once the first batch of IPs are licensed, we are pretty much good to go with the starting of the IBC. And then it is just a matter of when the government notifies the entire law, especially only on the corporate insolvency. We have not heard anything about personal insolvency so far. And as and when the law gets notified on the corporate insolvency processes and the first batch of IPs are licensed, we are pretty much good to go with the implementation of the law, with new cases coming in. Existing cases can also be dealt with under the IBC. And all the cases will essentially go to the NCLT. That will be the judicial tribunal to deal with the IBC cases. And with that, we'll essentially see the implementation of the law. So, I mean, we are perhaps not even 6 months away from seeing this law actually implemented on ground, which is a very, very fast process by Indian standards. And hopefully, once that happens, there won't be too much of litigation or other problems, and we'll be able to move forward with the law. So that's essentially where we are today. So I hope that gives a comprehensive and holistic picture of what the law is about and where we are going to go with this. And I guess at some point we can entertain questions through emails or whichever way this forum works. Thank you so much.
Thank you.
Yeah, Pratik and Rajeshwari, thanks a lot for the insight. I have few questions that I have in mind. So basically, if you can discuss a little bit more on the personal insolvency issues, it has not been notified. I understand the proportion has not been done, but can you explain a little bit more on the personal insolvency issue, how it will be done? Is it the same thing that as the corporate insolvency, or is it a bit different?
So I do not want to go too much into the details of the process because that will take up a lot of time, but to give you a very quick overview, parts of it is very similar to the corporate insolvency process. The only difference is in personal insolvency, essentially, the diversity across individuals is a lot more in India as opposed to the companies. So we have poor farmers, who may not have the wherewithal or the money to appoint insolvency professionals, and whose debt essentially would be a very small amount, to large landlords or even micro enterprises or partnership firms, which are almost very close to a corporate insolvency process. So the entire range of cases is a lot more and lot more diversified in the personal insolvency landscape. So there, the one additional provision is something called a fresh start. So when essentially a very poor farmer or somebody with very small amount of debt has defaulted, you do not want to do an entire recovery and resolution because the amount is so small, it may not even be worthwhile. So for those kind of cases, we are giving the opportunity of essentially writing off that debt and giving opportunity to that person, to the debtor, to farmer, to do a fresh start altogether with the same creditor or other creditor. So that the entire naming and shaming and social stigma can be detached, can be taken away from that entire process. And fresh start is something that is done in other jurisdictions as well. It's nothing new that we are doing. Other than fresh start, we still have that insolvency resolution process that will be applicable to individual insolvency as well, to partnership firms, to somebody who has a little bit of a higher amount of debt. And that can be done, and this will essentially be the case for partnership firms, where the insolvency resolution process will proceed with the help of an IP. And that IP will essentially again form the creditors committee and do very similar process like the corporate insolvency process. And then if at all there is a bankruptcy case where the person is absolutely bankrupt and there is no way that any kind of resolution can be done with that personal debt, then there will be bankruptcy process where again the assets of the person will be seized and the bankruptcy trustee, which is again an IP, will again decide how the assets will be sold to give the dues to the different creditors. So that part is very similar to the corporate process. The only difference being that fresh start, which is almost like a waiver that is being given. And the other caveat is, because in personal insolvency, in a lot of cases, IP fees may not be affordable by individuals. IPs may be required to offer the services pro bono. That provision has also been made into the IP legislation, that IP subordinate legislation, as to how pro bono cases can be dealt with by the IPs. So this is pretty much how the personal insolvency landscape is designed. The reason I'm also not going into the details is we have actually not gotten any sense as to when these provisions will be notified, if at all. And it's possible that a lot of changes will be made before these are notified, because it's a very sensitive thing, because it affects people like you and me. So a lot more stakeholders may want to be involved in the consultation process, and that may take a lot longer time. So that's why we are not seeing any movement, and there is also no consensus which ministry will house the personal insolvency law. So no movement has happened on that front at all. Thank you.
So basically, there might be a chance that like the personal insolvency part and the corporate insolvency part may be like separated and it's dealt with different ministry or departments. Might.
So it will definitely be dealt with different ministries, because Ministry of Corporate Affairs can only deal with corporate cases, corporate insolvency cases. It's possible, and I'm completely talking on my own, not from what I've heard, but it's possible that, let's say, maybe the law ministry will house the personal insolvency, some more neutral ministry that can deal with individual cases. But we don't know anything on this, there's no clarity. But what we know is it will remain as a part of the same law. It will not become a different law, because the idea is to have a single unified law for all entities. So it will remain a part of same law. It may just be dealt with different ministries.
Right, absolutely. Pratik, Rajeshwari, I'd like Pratik to answer because he's a lawyer himself. So basically, what are the opportunities do you think that will come up for lawyers, consultants, like CSCS and like other persons also, like in terms of, because you said discussed about insolvency professionals who are there. So what is the kind of opportunities do you think it will be there?
That's a very good question, actually. In fact, recently only we were in another talk when we were discussing this. So so there are two possibilities, right? So one possibility is that lawyers themselves can register as IPs. That, I mean, theoretical possibilities, I'm saying. So if lawyers register as IPs, then the only issue that seems to be cropping up is that there's a bar under BCI regulations that lawyers cannot charge fees based on the outcome of the case, right? I mean, you cannot do that under the present regulations on lawyers. Whereas the IPs, the entire mechanism seems to be structured so that there is a kind of the fees are based on outcomes, so that incentivizes the IPs to help out the company. So in case of IPs, it is necessary that their fees are outcome oriented. So in that case, there is kind of a conflict between the objectives of the two professions and the regulations that are there. So that's one issue. But otherwise, what can be done is, even if the IP is a chartered accountant, there will be a lot of legal issues that they have to deal with. And in all probability, you will find lawyers, whether they be counsels or law firms, being engaged for advisory purposes to the IP. So the IP will be supported by law firms and lawyers. That can be a viable model, and I think this is a new area for lawyers to get into, and the ones who are experienced in this field, obviously for them it will be a lucrative practice. And otherwise also, if you look at other jurisdictions, there are usually big CA firms get into the IP profession. So in India, unfortunately, this is not a developed profession, but in other jurisdictions, the developed jurisdictions, it's a very lucrative profession. So even if the chartered accountants are basically registered as IPs, for legal opinion, they will have to come to lawyers. So this will open up a wholly new market for lawyers, and that's why lawyers should be very much interested in this space and should start developing skill sets on this subject. And as we understand that the IP exam is going to be held sometime in the near future, so I think it's an exciting time for the legal profession.
What does the role of an insolvency professional look like? Is it more of a like what kind of role? Is it more like a mediator, or that person will actually do some due diligence, or what kind of work it will be involved? Like if you have an idea on that.
Right, so that could be more of a negotiation, right? Because the job of the insolvency professional is to ensure, see, his goal is very outcome oriented. He wants to make sure that within 180 days, the job is done. And therefore, in his interest or her interest, that the creditors committee is immediately set up and the creditors come to a conclusion as to the restructuring. So it may be, as I think Rajeshwari can probably explain this in detail, it's quite possible that some assets may be sold off to some of the distressed assets, may be bought out by some of the creditors and who want to get a 75% say. So there are n number of possibilities of transactions or deals happening during the 180 days period, and this negotiation phase has to be managed by the IP. So the IP's, I think, main role, as I envisage, is to shepherd all the stakeholders in a resolution process to come to a fruitful conclusion, so that if there is genuinely financial stress and not a business failure, then the IP's interests are to get the company's distressed debt restructured so the company can go on into brighter future. So Rajeshwari, you want to add something on the insolvency financing?
Yeah, so essentially the way it is designed right now, the insolvency professional acts as a bridge between the debtor and the creditors committee. So the role is going to be largely a managerial role, where the IP, and a very important part of the IP's function, is going to be taking over the business and the management of the company. And that is something that, even imagine a big company, that's a very, very big responsibility. So the IP from day one takes over the management, because the board of the company will be reporting to the IP. So running the company as a going concern is something that IP has to do. And then constantly keeping in touch with the creditors committee, keeping in touch with the debtor, that intermediation also has to be done. And finally, getting any kind of interim financing to keep the company going, getting all kinds of bids from the market to form the resolution plan. All of that work also has to be done by the IP. So it's a mix of a managerial role and intermediator between the creditors and the debtors. But just one thing to note here is the IP at no point has any say in the resolution plan itself. So how the company will be restructured, the IP has no opinion, no say on that. The IP is just acting as an intermediary mechanism who's getting the bids from the market, presenting it in front of the creditors committee, and communicating the creditors committee's decision to the adjudicating authority. The IP doesn't play any role in the actual restructuring and revival plan of the company. He's essentially doing a managerial role. Now that's in the first 6 months of the IRP, but the IP can also be a liquidator. Now when it dons the hat of the liquidator, then it's a lot more complicated task, because the liquidator then has to sell the assets of the company. And that can go on for 2 to 5 years or any time that's needed. And that kind of knowledge is a very specialized knowledge needed when you're selling different kinds of assets in the market and distributing the proceeds to the various creditors. So that's largely the role that the IPs are going to
Okay.
play.
Would you like to add on to the discussion, like anything else, like you think that might be relevant for the audience right now? Might be like just an ending note or something.
Well, I mean, the one thing that we would like to say is, I mean, this law on paper is, I mean, of course, we are biased because we have worked on it, but even objectively speaking, it is a very well-rounded, rooted in economic principles. It's a good piece of legislation that has come about. And it is very, very important in the Indian context because it is much needed and it's high time. Of course, a lot now depends on the implementation. Having a good law is one thing, but till it is implemented properly, half of these outcomes will not be seen. So I think we should all watch out over the next few months or a year of how the law is implemented and be involved in the process in whichever way is possible, giving comments on the law, giving comments on regulations that are coming out, reading the law, building our knowledge on the law, so that as and when amendments happen, as and when case laws start building up, we are able to, even as a student community, so that you're able to stay engaged, build your knowledge on it, because this generation of students or even people who are currently working in India are the ones who will see the implementation of this law happen over the next few years. To stay engaged in that commentary process, in the review process, in whichever way possible, I think that will be a very valuable contribution, and the more the better. That's the note that I want to end with.
Pratik, anything you would like to add?
Yes, I think it's a great opportunity for lawyers and especially people who are looking for with a long-term plan. I think this is a new practice area that will develop, and law firms have already started working in that direction. Even for law students, I think this makes a lot of sense because we have been talking to some law students in law schools, and there's a lot of excitement within young lawyers as well as law students. So I think this is one area where, as students or as young lawyers, you would obviously want to develop expertise.